Delhi High Court and Supreme Court, who have come to attend this swearing-in ceremony. Lord, I don't know the names of all of them. Some of them have arrived this morning, but kindly allow me to tell name of few prominent advocates who have come. Mr. Surjo Prakash Khatri, sitting chairman of Bar Council of Delhi.
Mr. Rajesh Mishra,
Sitting
Honorary Secretary of the Bar Council of Delhi.
of the Bar Council of Delhi.
Mr. Ramesh Gupta,
Former
Chairman Bar Council
former
of Delhi.
Chairman Bar Council of Delhi.
Mr. Rakesh, former
Sherawat,
Chairman Bar Council
former
of Delhi.
Chairman Bar Council of Delhi.
Mr.
Nirmal Akhtar,
former Vice Chairman of
former
Bar Council
Vice Chairman of Bar Council
Delhi.
of
Mr.
Delhi.
Ajinder
Mr.
Sanghvi,
Ajinder, former Honorary Secretary Bar Council. Not then Puneet Mittal, designated Senior Advocate. Rajiv Saxena, designated Senior Advocate. Manu Sharma, designated Senior Advocate. Jagdeep Sharma, designated Senior Advocate. Rajesh Kapoor, designated Senior Advocate. Now, they were kind enough to meet me yesterday evening. When I met them, I asked them, you have already paid your respects to the Honorable Justice Sharma at the time of farewell. Why so many of you have come to Calcutta? But they gave a free answer. They said, we have come to meet the Calcutta advocates and to tell them what blunder they are committing. They told me that, and if I don't attend his swearing-in ceremony, I'll always feel guilty before my conscience. But after talking to Mr. Ved Prakash Sharma, I decided that come what may, I will attend the swearing-in ceremony of Justice Sharma. But a few of my brothers and sisters are very angry with me. They feel I've done something unprofessional. Lord, therefore, Lord, because Lord, I'm speaking from my heart.
Yes, say these things.
Lord, therefore, Lord, some of my learned friends want to take action against me. Lord, come what may, I have decided, welcome. I once again welcome Justice Sharma and am sure of a most sincere cooperation.
May I now most humbly request the Honorable Justice Dinesh Kumar Sharma to address the House.
Honorable the Chief Justice, Honorable my esteemed brother and sister judges, physically and online, Honorable President and Secretary of the Bar Association, President and Secretary of the Incorporated Law Society, President and Secretary of the Bar Library Club, learned Additional Solicitor General, learned Advocate General, law officers of the Union and State, Chairman and members of the Bar Council of West Bengal, respected members of the Bar, Honorable Justice G.P. Mittal, former judge, Shri Surya Prakash Khatri, Chairman Bar Council of Delhi, Shri Rajesh Mishra, Honorary Secretary Bar Council of Delhi, Shri Neeraj, President, Central District Bar Association, New Delhi, Mr. Ramesh Gupta, Senior Advocate, former Chairman Bar Council of Delhi, Mr. Rakesh Sehrawat, Member and former Chairman Bar Council of Delhi, Mr. Himal Akhtar, Member Bar Council of Delhi, former Vice Chairman Bar Council of Delhi and Member Waqf Board Delhi, Mr. Ajinder Sanghvi, Member Bar Council of Delhi, former Secretary Bar Council of Delhi, Mr. Puneet Mittal, former Secretary Bar Council of Delhi, Mr. Rajiv Saxena, Senior Advocate, Delhi High Court, Mr. Manu Sharma, Senior Advocate, Mr. Ranjit Kapoor, former Additional Advocate General, Supreme Court of India, Mr. Anil Soni, Senior Advocate, Mr. Shubhendu Mukherjee, Senior Panel Counsel, Mr. Mangatram Sharma, IAS, Additional Chief Secretary, Tamil Nadu, Mr. Avdesh Mishra, Chancellor, North Cap University, my wife, Mrs. Vishakha Sharma, my brothers, Shri Rajkumar Sharma, former District Judge, Shri Jagdeep Sharma, Senior Advocate, my sons, Anirudh Sharma, Advocate Siddhant, Karthik, and my daughter-in-law, Manisha Ishita, and my grandson, Stavya, my entire family through online, and DP Singh and Devinder Yadav. It is with great humility and a profound sense of duty that I am before this august gathering, having taken oath as a judge of the Calcutta High Court, I express my sincere gratitude to Honorable the Chief Justice for administering the oath and for the gracious welcome extended to me by this court and its vibrant legal fraternity. I must say that this is not coincidence that I am here. In fact, since my early childhood, I was mesmerized with the personality of Swami Ramakrishna Paramhans, Swami Vivekanand, Guru Rabindranath Tagore, and Subhash Chandra Bose, and many other Bengal literary luminaries. In fact, many generations back, they say that our forefathers moved from here only. So basically, it is homecoming. I am a firm believer that everything happens with a reason. So the destiny has sent me here to serve the people of Bengal. To join this prestigious institution is an honor, one that carries with it the responsibility of extraordinary history and tradition. The Calcutta High Court, the oldest charter high court, stands not merely as a judicial forum, but as a cornerstone of India's legal heritage. This court has been home to pioneering minds and landmark judgments that have fundamentally shaped our nation's constitutional jurisprudence. Its intellectual richness and fearless commitment to the interpretation of law have made an immeasurable contribution to our nation's moral and legal fabric. This very court saw luminaries like Justice Gorodas Banerjee, the first Indian Vice Chancellor of the University of Kolkata, and graced this bench. It was from here that Justice S.R. Das rose to become the fifth Chief Justice of India, and many other legal luminaries who contributed in the side of the bar and the bench. Even architecturally, this court, inspired by the Cloth Hall at Vipers, stands as a majestic symbol of dignity, order, and enduring strength. There are many other legal luminaries to whom I may not be able to name for the sake of brevity. In the moments of transition, I often find comfort and clarity, not only through the lens of law, but through the poetry of Guru Rabindranath Tagore. His words offer a quiet strength, and I find myself turning to them once again. Let life be beautiful like summer flowers and death like autumn leaves. These lines speak of grace, not only in beginning a new chapter, but in fulfilling one's duties with beauty, dignity, and purpose. I come to you from Delhi High Court, an institution where I had the privilege to serve alongside exemplary judges and lawyers from whom I have learned immensely. My years there reinforced my belief that justice is never delivered in isolation. It is a collaborative endeavor built upon preparation, patience, and compassion. This transition to Calcutta represents more than a transfer. It's a continuation of that collective pursuit of justice, now set within a different historical and cultural context, one that has profoundly influenced India's legal, philosophical, and political thought. As I said, that since childhood I was immensely mesmerized and impressed by Swami Ramakrishna Paramhans and Swami Vivekanand. In fact, after coming to Kolkata, first thing I went to Belur Math and took the blessings. From Swami Ramakrishna Paramhans, whose life and wisdom were rooted in this very soil, I find inspiration for judicial conduct. Quote, unquote, if you desire to be pure, have firm faith, and slowly go forward, but know this, you must be sincere. Sincerity is everything. Another teaching that deeply resonates with me, a tree laden with fruit always bends low. If one has acquired learning and power, one must be humble. These words remind me that humility must accompany knowledge, a truth we must carry with us every time we step into the courtroom. In the same spirit, I find guidance, and this is the motto of my life, which is in the word of Swami Vivekanand, quote unquote, arise, awake, and stop not till the goal is reached. For us in the judiciary, the goal is not a destination, but a continuing pursuit of justice that is inclusive, equitable, and clear. It is our solemn duty to uphold the constitutional vision, especially for those who may lack the means or strength to assert it. The Calcutta Bar is known not just for its scholarship, but for its passionate advocacy and unwavering moral clarity. I have long admired the bar of this court and look forward to building the kind of open, thoughtful dialogue that advances justice not only efficiently, but meaningfully. To my colleagues on the bench, I extend my complete cooperation and collegiality. The collective wisdom on this bench is deep, and I remain committed to the deliberative process that lies at the heart of the principal adjudication. As I take on this new responsibility, I do so with full awareness of the trust reposed in this institution and its honorable judges. I seek the blessings of the Almighty Ma Kali, the support of my colleagues, and the goodwill of the bar and the people of the West Bengal. I assure you that after my tenure here, you will have the same love and affection which my friends who have come from Delhi. I pledge to serve this great institution with integrity, sensitivity, and an unwavering commitment to the Constitution. Let us continue together in our shared mission to uphold justice, not as a symbol of authority, but as a promise of fairness. Before parting, I'll definitely say, see me as one of you ready to stand alongside you. अपना देश शोभाय के आंतरिक शुभेच्छा ओ बांग्ला नववर्षर अग्रीन अभिनंदन. जय हिंद. Thank you.
May I have the leave of your lordship to declare the proceedings as concluded? The proceedings are hereby declared to be concluded.
या अल्लाह, जिसने मुझे कॉल किया उसे सारे जहान की खुशियां नसीब फरमा। या अल्लाह, हमारे मुल्क में अमन और सुकून अता फरमा।
My lord.
After a long time before your lordship, I have mentioned this matter for increasing the list, my lord.
Upon notice,
But I have served notice previous for many times, my lord. I shall serve and come.
please
Yes,
see the,
yes, yes.
see the instruction on only on Monday.
I get
I leave to file an appeal with a server copy.
Your Lordship, I'm the petitioner in person. This is regarding FMS 2447 of 2007. My case was heard by your Lordship on 12 December and 24 December 2019. The final order was,
2019.
your Lordship, final order was not passed because of the lockdown was declared. Thereafter, case was heard by court number 11, when court number 11 on
Are you mentioning
Yes,
about,
yes,
are you
yes,
mentioning about notice?
they have appeared also in 25th March.
Please, they mention.
25th March. Notice this.
No.
এটা ওনাকে দেখাতে চাচ্ছি। This is order, roll order, and this is
Yes, we noticed that.
the case number, court number 11 has transferred the case to your lordship case because they want the case to be decided by city civil court, which I could not agree, your lordship, because I am now 80. How can I wait for another 81? This is the mention in slip, your lordship. এই অর্ডারটা আমাকে দিন।
Order ফেরত দিন, order ফেরত দিন. Yes. Yes.
Well, it may be permitted to.
Please maintain the seniority, please.
Yes.
Allow the seniority.
May I have your lordship's kind leave to mention 3 analogous old matters, my lord, pertaining to the year 1983, my lord. 1983, my lord. My lord, the matters were mentioned before Honorable Justice Harish Tandon. 83, my lord.
40 years.
My lord, the matter was mentioned before Honorable Justice Harish Tandon. My lord, my lord.
Now, are you mentioning about notice?
My lord, I have served notice several times, but none of them are turning up, my lord.
I don't know. If you
My
are
lord,
mentioning-
my lord, my lord.
Mentioning today, you have to give notice, madam.
My lord. Thereafter, the record was searched. It was found that the second judge's copy in the record was missing from the records, my lord. My lord, I have provided a copy of the memorandum of appeal to the registrar administrative department, my lord. Thereafter, they say that I need to mention the matter so that the records can be reconstructed and for the acceptance of the same, my lord. My lord, sir. My lord, much obliged.
May I be permitted to mention one matter?
Not be senior amongst you.
But I may be permitted to mention, my lord, with notice to stay application in relation to my lord group 2. Urgency is there, my lord, regarding one is.
All matters are argued.
Lordship, this is without notice, Lordship. I am the advocate on record. I have not received any notice, Lordship.
Said he has served notice.
Yes.
Lordship, I have not received any notice, Lordship. I am the advocate on record of this matter, Lordship. পীযূষ কান্তি করছো তো? I am Kaushik Chaudhary. Have you served Kaushik Chaudhary?
Atul Vishwas.
Lordship,
Sir,
this is,
Atul Vishwas.
I am the advocate on record, Lordship.
Atul Vishwas also appearing for the Board of Primary Education.
But I am the advocate on record, Lordship. You have to serve me, Lordship.
Why?
Yes.
Lordship, may I have a kind leave to mention a matter for correction, my lord. There are certain typographical errors.
May I be permitted to mention one matter? May I be permitted to mention one matter, your lordship? This is the first appeal, your lordship, for inclusion.
Upon notice.
Your lordship, I have tried to serve the notice, but the advocate said that he has lost contact with the client.
File the notice, then we will consider it. Give a notice. If he refuse, say so, then we will do it. Yes.
My lord, may I have your kind?
Without notice, no, please no mention.
May I have your kind leave to mention 2 substitution applications in connection with first appeals, my lord?
Your lordship,
May I permit to mention a matter, lordship?
Yes.
May I be permitted to mention one matter, your lordship? This order has been passed. This order has been passed by your lordship in a previous bench, but in the order, the testamentary suit number has been wrongly recorded as TS6 instead of TS7.
Correction.
Yes, your lordship.
Won't bench the
your lordship, I am appealing for the petitioner.
May I permit to mention?
A bench.
Your lordship, it will be TS7.
Which is incorrect.
Your Lordship, the testamentary suit number TS6, it's written. It will be TS7 of 2022.
You mentioned it here.
Lights, Your Lordship.
My lord, may I permit to mention? My lord, I'm mentioning for inclusion, the admission, it is for admission of appeal for the first time.
Yeah, permitted to mention for inclusion the list.
Your Lordship, I am appealing for the petitioner.
Yes.
That leave without certified copy. Second, the date was, the order was passed. 2nd of April.
Yeah, apply for the certified copy.
Yes, I have.
Have you given the slip? Slip is there.
Your Lordship, mentioning for inclusion. I have said the other side. I permit to mention on my Lordship. For inclusion in the list, Your Lordship, this is the first appeal of 2010, Your Lordship.
May I have my lord's?
Lordship, may I be permitted to mention one Group 2 appeal for inclusion in your Lordship's list? Group 2 appeal. I'm mentioning about notice, your Lordship.
May I be permitted to mention one Group 2 hearing, my lord? Group 2 hearing, my lord. One stay. May I have my lord's kindly to mention one stay application in connection with an first appeal, my lord?
Lordship, item number Y, applying with the state ability.
Not this week. Who is for the respondent?
Lordship, in this matter, Mr. Amuleshwar is appearing for the respondent. Mr. Amuleshwar is appearing for the respondent.
Staying for 1 week's time.
Can it be, my lord, in the week commencing 21st, my lord?
21st. Prayer of the Right Council for the appellant. Matter is listed on. Matter should listed on 21st April. 21st.
Grateful, Lord.
Prayer for attendance of the respondent. About the other respondents have also prayed for an activity. Is there something to do this matter listed on 21st? Yes,
So once this was ওদের এফিডেভিটটা কই তুমি ওদের এফিডেভিট পেয়েছো স্টেটে উচিত ছিল তোমাকে তো আমরা
স্টেটে কোনো এফিডেভিট দেন হ্যাঁ সাপ্লিমেন্টারিটা
স্টেট কই স্টেট তো না
স্টেটে কি আছে state board.
So this was last heard on 8th February
exactly
last year.
Namala, the presence of the state is required. I just tell you the point.
We have seen the order of 16 January.
The status report your losses wanted from state in regard to the draft rules. They have filed an affidavit, but that's also an age of 1 year more. Now still it's and in the stage of the draft. That's all. I'm not fine.
Because he has to.
He has to know.
Take down. Affidavit has been recorded.
We have been served, my lord.
কপি আছে সবটা
আমাদেরকে দেয়নি যে কোরেসপন্ডেন্ট তোমাকে ওই জন্য দেয়নি
দিবে তো
চাইতে হবে তোমাকে
The state is not represented.
বুঝতে পারবে
That is listed almost after a year. Past year. Yes, Mr. Bosumali, what is the latest status report?
My submission. We have filed our affidavit.
The affidavit is not on record.
Yes, we have. But my junior told that everywhere is notified. Only that.
Your respond number? No. Respond number 4 has given. That just.
Respond number 1.
Yes. Respond number 1 has given. It will be,
No copy has been served or not. I will tell my.
You are not required. This is for between here and the state.
আমাদের কত রেসপন্ড নাম্বার 4 and 5 না না আমাদের
But I think page 4, paragraph D, that's important.
You take the instruction in the meantime because it was filed 1 year back.
That's it.
It appears from record that this matter was heard last by a coordinate bench on 28th of February. Sorry. 25th February 2025. It was heard last on 25th February 2025. When direction was given for exchange of affidavits. Mr. Bishop Oshimoli, the current AGP, has referred to paragraph 5, subparagraph D of the Appin opposition. Submits that he has not received any instruction as to whether there has been any official ticket notification. The affidavit was upon on 16th April 2014. 16th April 2014. Matters are adjourned for a fortnight.
হ্যাঁ নোটিফিকেশন এর তো সবাই জানতে পারবে পাবলিকলি এটা কোন স্টেট কি স্টেজে
A further affidavit shall be filed with the present status of the draft rule. The present status of the draft regulation, which has been sent to the law department for the purpose of legal vetting. The matter shall be taken up with the law department so that by the adjourned date, the state is in a position to communicate the decision.
After 2 weeks. দিদি আপনার স্কুল ওইদিকে চলে যেতে হবে আমি তো এইদিকে হ্যাঁ হ্যাঁ অ্যাপিলেন্ট তো তুই কার
Appellant. All appellants.
No response.
46. Okay, sir, for the which petition I responded.
I'm appellant for the one of the.
All the hearing matters.
What happened to your matter?
Yes.
You are preparing a SLP now.
But that airport. Thereafter, I didn't.
Please let us know because similar matter is pending before us.
I'm not aware because that was not.
Find out. Please find out. So, because similar matter is pending before us. And please let us know.
Yes,
Otherwise, we follow our judge.
These are the matters, my lord.
Primary teachers.
My lord, if your lordships kindly look your lordships order of
17 January 2020.
on
17 January.
17 January, my lord.
4th September.
এটা লাস্ট হয়েছিল।
দেখে নিলাম
17 January 2024. 17 January
Will
2024.
not take up this matter.
Wallet?
Will not take up this matter.
Lordships protected us.
Take off.
প্লিজ করে দিচ্ছে
Oh no, they release matter.
No, it's not inclined to take it for personal reason.
My lord,
Personal reason.
no, no, personal.
পার্সোনাল রিজন ছেড়ে দাও
Not inclined to take up the matters. All the matters are released from this bench.
তারা শোনা আরে সে কি করবো তো রিলিজ হয়ে যাচ্ছে
Justice for us.
So my lord is releasing this matter. Just a minute.
Let the matter be placed before the honorable.
আরে সে তো ইউজুয়ালি তাই হয়। ছেড়ে দিলে নতুন করে
না থাকলে হবে না স্যার, আমরা সাফার করবো, না থাকলে হবে না।
My lord has released this matter.
ভেরি গুড
না আমাকে দর্শকের কেস করলাম তো ব্যাড লাক
Deeply obliged, madam. Deeply.
এতেও deeply obliged. এতেও deeply obliged. May I leave, my lord?
58, my lord, has come up at our.
Lordship, I'm appealing for the university being led by Mr. Amita Vachutri. Item number 48. 48, man.
ওটা তো কপি কেমন করা আছে ওদেরকে একটু
Cost right. And on the 17th of March 2025, the previous bench, my lord, decided over by my lord Justice Chandler was pleased to allow by section 5 and also, my lord, directed my lord can 2 to appear in the list. Now, my lord, apparently can 2 contains all the papers, my lord, used before the learned court below. Before the honorable single judge. But the issue here is, very briefly, my lord, the issue is whether, my lord, the persons who are working in the messes and hostels of Kolkata University, my lord, whether they at least are entitled to a basic pay at par and commensurate with the regular employees. They might not be regularized in that sense, but equal pay for equal work principle, may not whether would. Yes, no, I've got that judgment. The recent one. Shipal was decided on January 31, 2025.
জাগ্গো আগে তারপর শিকার হ্যাঁ একটু দাঁড়িয়েছে তো সব তো দাঁড়িয়ে ছিল
স্টেট আজকে স্টেট কেউ নেই
But we delivered a judgment at the division bench.
I'll check it and come back.
কি জাজমেন্ট এটা লাস্ট জাজমেন্ট কি জাজমেন্ট এটা লাস্ট জাজমেন্ট Padavi continues to justify exploitative engagement. Supreme Court allows regular long certificate.
জানিস 25 SCC online 221. 2025 SCC online 220. 2025 SCC online 221. I'm giving your lordship, judge.
Tripal. ছেলেকে কি করেছে অ্যালাউ করেছে
রেগুলারাইজেশন এই মুহূর্তে না তাতে একই লোক আমি সেটা
Were appointed on contractual basis.
No, my lord, we were not appointed on contract. We were, my lord, daily wages.
Yes, my lord. In other words, it is contractual basis.
That is the issue of dying cadre.
Yes, my lord. Yes.
There is an issue of dying cadre here.
Dying cadre. They approached this court after announcement of dying cadre by the state. Subject to approval of the state. Up to a particular cut-off date, this court allowed all. Thereafter, petitioner approached, so petitioner was not in a position to come within the purview of that job.
Because of the cut-off date.
Because of the dying cadre. Apart from that, my lord, in this petition, the petition came after the division bench judgment of this court, my lord. Initially, writ petition was allowed by the honorable single judge. Thereafter, state and university preferred appeal before this court. My lord, the appeal court granted liberty to petitioner to deposit one representation before the state, and in that representation, petitioner never uttered any word for equal work for equal pay. So, my lord, birth of the writ petition is that representation. So according to that representation, now we will rely on qualification. When the matter was going on, my lord, I said in my affidavit, supplementary affidavit, that petitioner was agreed to enhance their fee. They will not proceed with the writ petition. In spite of that, my lord, we increased salary during the pendency of the matter. In spite of that, my lord, they proceeded with the matter, though no written undertaking was there. My lord, this is the short gist of the matter, my
Because
lord.
of paragraph 39, you cannot claim anything more.
I'm sorry.
Paragraph 39 of the judgment.
Your lordship, sir, of the judgment and order under appeal.
This is the criteria which is being followed. Even in state, even in high court. Secure their employment and this is in consonance with the state government's notification of maybe of 2015-16, which is revised from time to time.
The Honorable Court, by disposing of the writ petition and internal page 15 of the judgment and order under appeal, the university in fact has implemented the principle of equal pay for equal work by providing the petitioner remunerations at par, which is perhaps not a correct position factually. This is not the correct position. Factually, it is not correct. Because the regular employees, your lordship will kindly bear in mind.
No, you see one thing, if they are doing the same kind of job, we have delivered the judgment in a matter in a division bench with regard to the contractual teachers. We say that their salary has to be fixed. They may not get other benefits. But since they are doing the same kind of thing as any other teacher, so sir, their basic pay should be the same. They may not avail of other benefits if they have been absorbed. That was our judgment. I think the SLP was either not preferred or preferred, but no interference with that. So that was in respect of a contractual teachers in the college or university, can't remember.
In this case,
now here also I think there is a government circular 2015-16. What they do is this: you have to pay the minimum basic wages. So basic wages, then ad hoc certain payment after they attain the age of 60. So their service is retained. If that is the, are you paying them the basic wages?
No.
No, my lord, may I point out, my lord, one thing, my lord? My lord, what has fallen from your lordship so far, my understanding is concerned, my lord, your lordship is telling about the contractual employee and they are getting some basic skill. My lord, in this case, subject to correction of your lordships, my lord, they are not contractual, they are not getting any basic skill, my lord. They are day-to-day basis engaged.
No. What we are saying is this: just by
no consolidated amount is there.
They are daily rated wage earners. Daily rated wage earners. They are all daily rated wage earners.
Daily rated wage earners.
If they are, say, DRM, Mosdurs, and if they work for 240 days continuously, then you have a problem. They may raise an industrial dispute. Of course, you are now at university and school.
That's continuous work not there.
Now, whatever is there. So you are a state. Continuous there or not there is a different.
Continuous is not there. We are working regularly in the hostels.
So don't
hostels are being managed by you.
Give them the basic wages, whatever the fix. What is the basic wage? Now, if this is the basic wage, if it exceeds basic wage, fine. If it doesn't exceed the basic wage, you have to give the basic wage. And then resolved to enhance. So paragraph 40 takes care of your case.
No, it doesn't.
Why?
Paragraph 40 just records whatever we are receiving. As against a regular employee, that is far less. I am not on the question of gratuity or leave encashment.
Basic wage.
At least in terms of Jagjeet Singh's judgment, which has been relied upon by the Honorable Single Judge, read with Umadevi, and now Sripal has come, and your Lordship's judgment, what I am respectfully submitting, Shripal,
শ্রীপাল কপি আছে শ্রীপাল একটা কপি আছে আছে
no, no, no.
না ঠিক আছে
Kindly see paragraph 5.
আমাদেরকে দেখতে গেলে 14 ছিল তো প্যারাগ্রাফ 14 আমরা
আমি দেবো স্টেটকে নোটিশ দিয়ে দেবো এই স্টেটকে কে আছে জানো সপ্তক 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 কখন দত্ত না পয়লা খোলার চেষ্টা করো
Kindly see paragraph 15, 14, 15, particularly.
It's 76.
Here it is a case already different, dismiss,
Yes.
industrial disputes.
But Milord, it relies on Jaggo in paragraph 15. Kindly see.
To give them the basic minimum wages, that is what we will say, nothing more than that.
My lord, first of all, my lord, your lordship knows that, my lord, Control of Expenditure Act is there. Section 3 says, my lord, we have no role to play in this matter.
Government is not a party.
And, my lord, earlier division bench order, my lord.
State was not a party.
Yes,
Yes,
ma'am.
yes, state appeared on the previous day also. Milord, kindly looks into the last order made
My
by
lord,
the coordinate bench.
most humbly, my lord, I would like to submit before your lordship that, my lord,
Milord, Mr. Siddiqui is appearing. Milord, I'll inform you.
my lord, this writ petition and the appeal is the outcome of an representation which was framed by the guideline framed by this division bench. And my lord, in that division bench, before the division bench, petitioner did not ventilated his grievance, my lord, in this way, in this fashion, in this particular point. Thereafter, in spite of the liberty was granted to the petitioner to deposit representation. But in that representation, there is no whisper of equal pay for equal work. Accordingly, writ petition was before this honorable court, and thereafter, my lord.
No, where is the order of the division bench?
My lord, page 221 of this stay application, my lord. Honorable Justice Dikankar Datta and Honorable Justice Pratik Prakash Banerjee's order. In that, accordingly, petitioner deposited their representation. But in that representation, there is no whisper of equal work for equal pay. So, my lord, as on today, by filing this appeal, my lord, petitioner cannot claim equal pay for equal work. Petitioner should have been approached the Honorable Supreme Court challenging the division bench order. Or, my lord, petitioner, the representation which was deposited in compliance of the Honorable Division Bench order, my lord, petitioner should have ventilated his grievance before the state authority. Because it is the direction of the High Court. State authority will decide the entire issue. So, my lord, the state authority was not in a position to consider the issue. At least my humble submission is this, my lord, your lordship can grant liberty to the petitioner to at this point before the competent authority, and competent authority will again competent authority will may decide if your lordship desires so. But now petitioner is not in a position to improve his case, because the birth of this appeal and the writ is the order of the division bench and the representation. Petitioner cannot travel beyond the scope of that order, my lord, of that representation. Subject to kind correction of your lordship.
বলা হয়ে গেছে বলা হয়ে গেছে আর কিছু বলবো বলে দাও তাহলে আমি বসি আমি তো আমার অ্যাপিল তুমি বলে যাচ্ছ তো
While the writ petitioners.
Representation, my lord, kindly come page 167.
While the writ petitioners in the previous proceeding, University of Kolkata was Ranjit Sarkar. Were you the writ petitioners? You were there.
Yes.
You made a representation, correct?
Page 167 of the stay application. And operative portion
What
is
is your grievance? What is your grievance?
169 is the operative
What
portion.
is your grievance?
my grievance from the first day is regularized initially. But there are orders which are a part of this record which show that not apropos the orders made by your lordship's court, not the department has granted or regularized certain persons. We had missed the bus at that point of time. We came a little later, by which time, my lord, the government notification of 2014 came to the situation. I mean, this honorable court, in the first round of litigation, disposed of the matter, relegated it to the government. The government came with a decision that it is not possible in view of the dying cadre situation. This cannot be done. Writ petitions were carried to your lordship's court. This honorable court, the division bench, your lordship has seen this honorable single judge, from which the division bench proceeded to pass the order. The honorable single judge allowed the writ petition by setting aside the decision to an extent and directed some protection to be granted. From that order, the state and the university both carried appeals. Ultimately, the appellate court relegated the matter to the Principal Secretary Education Department. Before the Principal Secretary Education Department, we carried on with our grievance regarding this dying cadre issue and non-regularization part. We carried. There is no dispute. I agree with you. The department has now given a decision which was under challenge before the Honorable Single Judge. In course, in the writ petition, we have pleaded that we are at least entitled to, apart from the other issue, we are entitled to at least some protection insofar as pay is concerned. Today the Supreme Court, in a series of judgments, is laying down this law subject to correction that temporary employment for a considerable length of time, they are not maybe entitled to permanence, because there may be their appointments may not be in a just and proper manner. They may be irregular, and having regard to such irregularity, they may be conferred some basic protection to the extent of some salaries.
Here the salaries have been fixed.
The salary has been fixed not by them. It is not by the government. The government has issued circulars even as late as in 2024.
But they cannot make any payment unless
the government has to answer. I am not the university, of course, is the university.
The government has to be heard. Where is
the government? I'll put the government on notice and come back on an NBA.
Government has filed an affidavit.
No, in this matter, no. In the writ court, yes.
What was the stand of the government? The writ court.
The stand of the government. You know, the affidavit of the university is page 184. Just give me 2 minutes. My lord, page 228. 228. The stand is at page 229, paragraph 5.
Sir, 229.
229, paragraph 5. It's a part of the state. It's the part of the government's affidavit, that your lordship will be pleased to find, at page 228. It begins from page 228, just for your lordship's clarification.
Which paragraph?
229, paragraph 5.
Where you appointed against any vacant and sanctioned post?
I won't say yes. But there are vacancies which we pointed out. I won't say, that we were.
Is there any circular of the government which extends regular pay scale to daily wages?
Daily wages, the government has come up with recent decisions. Of 2024, I have to use an affidavit. Those were not a part of the before the honorable single judge. The recent decisions say, that a person who is working as daily rated employee who is working for 3 years, 5 years, 10 years, 15 years, they will be entitled to some remuneration.
My lord, may I submit one thing, my lord?
After hearing the land counsel for the parties, we are of the view that the state is required to be heard. State is not represented.
Just
We request the Ghana GP appear on the agenda date with an instruction as to whether benefit of regular pay scale, whether there is a scheme or order / notification by which the benefit of regular pay scale extended to daily wages, as in the instant case, it is not in dispute that the appellants are all daily wages presently working under the university, presently working in the Kolkata University. The matters are adjourned for a fortnight. This order shall be immediately communicated to the government figure.
Someone who is completing 20 years of service to the decision of the government, 39,000.
Just wait for information. The Ghana GP is also requested to find out whether the present appellants can be extended the benefit of regular pay scales having regard to the fact that undisputably they are discharging the work of a regular employee for many years, continuously for many years. Continuously for many years.
My lord is keeping it,
For a fortnight.
Great. Let's have no.
My lord, in the meantime, we will take instructions, my lord. দাদা কি বললেন? In the meantime, আমরা instruction পাবো। Instruction. On দিয়েছো?
I'm seeking your lordship.
Take it back.
Is it your lordship's desire that we place on record the government decision finding of an appeal?
You want to? Brother, before that, please communicate the decision to the chief.
100%. 100%. Stipulate judgment of it.
My lord, we will take instruction, my lord. A grateful one. A grateful one, lord.
आज को टाइम ले जितना नोटिस
Six of the application.
What is the matter? What is the dispute?
My lord,
What happened, Lord?
applicant's husband was the headmaster of a school. My lord, proceeding being initiated against him, and he was then thereafter suspended, and he was terminated from the school. And appeal was preferred. Appeal was also, my lord, decided against the headmaster, and this application was filed. My lord, during the pendency of the said application, the headmaster expired, and his wife was added as a party out here. So she was proceeding with this appeal. My lord, what has happened is this, my lord, since 2005, the problem initiated against between the headmaster and the management of the school. He made several representations before the authorities that the management is not cooperating with the proper functioning of the institution, and those things, my lord, headmaster made representations for taking appropriate steps, my lord, so that the school could function regularly. My lord, thereafter, your lordship, while the headmaster was on.
What was the nature of the charge?
My lord, defalcations of money of the fund of the institution.
Appeal committee has already decided against the headmaster. That is the observation of paragraph 36 of the.
No, where is the charge sheet? Let us see.
Yes, lordship.
166 of the Lord application.
পজিশনটা দিবেন না
দিয়েছিল
অপোজিশনটা অপোজিশন
My lord, charges, my lord, at page 96 of my application. It's charge number 10.
67. It starts from 67.
We want to see the charge sheet.
It starts from, your lordship, page 64 of my application.
What are the charges? Where is the charge sheet? We want to see the charge sheet.
It starts from page 64.
That is not a charge sheet. That is not a charge sheet. This is report of the inquiry committee.
No. The charges.
My lord, Mr. Bari is leading us in this matter, your lordship.
No, but we want to see what.
Yes, lordship.
Well, you are appealing this matter.
Yes,
So
lordship.
tell us, where is the charge sheet? We want to see the charge sheet.
Charges will be not from the Lord.
Charge sheet
MP
is
not
not
on
there.
Lord. From the MP not on Lord. Charges will be appealed Lord. One
Charge-
specific.
You have not annexed the charge sheet, the basic thing.
My lord, the charge, my lord, starts from page 70 of my application. This is charge number 2.
No. That is not just.
And charge number 1 is at page 47. At page 67 of my application. This is the charge number 1. Charge number 1 is that Mr. Malikustur Rahman, headmaster, now under suspension of Amgoria Gopalpur RGM institution, had collected a sum of rupees 5,726 rupees on account of cultural fund of the school for the year 2005 and 6, and kept the said money with him without any resolutions of the managing committee. This is the charge number 1. And this, my lord, it goes on, your lordship. There are several charges being leveled against the headmaster. And my lord, the headmaster could not appear before the inquiry committee. And he couldn't represent himself. My lord, he alleged that he was not allowed to go to the school, and he was apprehending, my lord, that some wrong will be committed by the management. And he requested the authority for help, your lordship, but that was not. And the school, your lordship, it is as it will be evident from this, that in spite of serving notices upon the headmasters, my lord, headmaster couldn't go and appear before the inquiry committee. And inquiry committee, my lord, proceeded against the headmaster, and my lord,
It's the legal information order. It's a speaking order. Everything has been touched upon by the
my lord, is there. The only thing, your lordship, all these charges, that is of defalcations of all these amount, my lord, petitioner, yes, lordship. My lord, what has happened? What is this? That petitioner initially appeared before this honorable court, and he had filed his objection. he filed his reply. In reply, he lordship, certain documents he has filed. And those documents, it would be evident that with regard to the defalcations of amount, that allegations that's been labeled against him by the school authority is not correct.
Yeah, before the authority concerned.
That he did not.
Why you did not?
My lord, he alleged that, your lordship, he was not allowed to.
Basis of the records it was
Yes,
done.
yes, lordship. But my lord, while my lord proceeding expertise, the person, the authority who is proceeding expertise, he should have, my lord, been more careful while dealing with the case. And it was not that, my lord, that they did not have those documents that the headmaster was relied upon. There are certain documents. My lord, it would be evident, my lord, from page 113, that in a proceeding, your lordship, the headmaster appeared before this honorable court and filed his reply. And in the said reply, he relied upon certain documents. And all these documents are in connection with the charges that have been leveled against him with regard to defalcations of amount. And it has been stated by him that out of his own pocket, he had paid money to the para-teachers, to the teaching and to the non-teaching staffs and various other persons that were not taken into account. And if those amounts should have been taken in consideration by the inquiry committee, then at least there shouldn't have been any charges against him.
You have produced those documents. You should have participated in the proceeding.
A participation, my lord, he could not. He did not, in fact. My lord, kindly take, my lord, page 113.
Reply before the trial court?
Pardon, my lordship?
To annex those documents?
Yes.
In your reply?
Yes.
Trial
Let
court?
kindly, my lord, turn to page 113. 113. And my lord, I was suspended in the year 2006. No suspension allowance was paid to me. And the suspension continued for more than 4 years without any pay. Nothing.
You have not chosen not to defend the inquiry proceeding.
Court cannot be a fact-finding authority, isn't it?
But these documents were before them, your lordship. My lord, kindly, my lord, page 114, I will place before your lordship certain paragraph that the reference to the,
Agitating before the court.
my lord, these documents, my lord, it was filed prior to the, my lord, the inquiry departmental proceedings.
If you are saying that you feel insecure, should approach the Reed Court for assistance, police assistance, or any independent place where the inquiry can take place. If you are feeling insecure to appear, you should approach the court with that prayer.
He was assured also, my lord. I have finished in opposition also. He was assured to participate, no need of security. If they want, he can take steps. We annexed the documents also in the opposition.
Not appear in the inquiry proceeding, your lordship. He could not appear in the inquiry proceeding, lordship.
My lord.
These documents you have annexed to your reply, which you couldn't produce it.
It was filed, you were served upon them. Because after considering
Documents you were ought to have produced it before your authority concerned, isn't it? But you couldn't produce it because you were absent. Those
I did not. My lord, the headmaster, husband of the appellant, he did not appear before the institution, before the inquiry committee. He didn't participate in the. That's it. That is it. But still, your lordship, irrespective of that, I cannot improve my case. What has happened, it was done. But these documents, your lordship, it was before the school authority. These documents were before the school authority. Now, while proceeding ex parte against a person, your lordship, yes, your lordship. My lord, while proceeding ex parte, it is a separate issue while contesting. While proceeding ex parte, your lordship, these documents, when it was there before them, they should have taken into consideration. Ex parte, because that is the proceeding, your lordship, that we have.
No. So far as the inquiry report is concerned, the disciplinary authority must have given you a show cause. You have replied to the show cause. Have you?
Yes, reply you had given. Reply you had given.
So what is the procedure? After the disciplinary proceeding has called for a report and gives you a punishment, is there any appellate authority?
Yes.
So have you made any representation of the appellate authority?
Yes. Appellate authority, your lordship, simply rejected as I was not, I did not appear before the inquiry committee and I did not participate in the proceeding. That was the only ground.
But what documents you have produced along with your representation? Now, if these documents you have not produced in the inquiry officer before the inquiry officer, then also they could not examine you on those documents. It will be one-sided statement.
Page 126.
Understand?
Yes, sir.
If you don't participate in the inquiry proceeding and now you say these documents are relevant, who will vouch for this? You are not being examined in the inquiry proceeding. So these documents by itself is not sacrosanct. You had the opportunity to defend, you did not defend it. And then you cannot come and say these documents are relevant for the purpose of consideration. That is not sacrosanct. That is not sacrosanct.
Mr. Paris.
Mr. Bari.
Mr. Paris.
Documents before the inquiry officer in your answer. Your junior said there are documents which are not being considered by the appellate authority.
Yes.
First of all, these documents have been produced by the inquiry officer. If these documents were not produced either before the inquiry officer or before the disciplinary authority, at the appellate stage, you cannot come and say these are the relevant documents.
No, question is, my lord, he was prevented or he.
We are not accepting it. We are not accepting.
Anyhow, apart from this, the approval of the board, suspension and also, my lord, the dismissal, everything, it is required to be supported by the reason. I have categorically mentioned before the trial court, my lord, the judgment has been quoted, but there is no findings of that too. If your lordship kindly takes up the judgment, আমাকে ব্রেকটা দাও না।
No, this document today is this petition today is immaterial because because in the first writ petition that you are prevented and other things, the revocation of the suspension, this was decided against you, and the appeal court also did not interfere with that finding.
No, madam, the appeal court, it is not that the merger will apply. The appeal court, the trial judge said, no, appeal court, you could not. Appeal court, entire matter was merged with the appeal court decisions.
No, so trial court did not, the first trial court, they found that your allegation that the entire things suspect, the committee says we have to suspend him because he's not accepting the charge sheet.
Yes.
And the first court came to a finding that the school tried his level best to serve, but he avoided. That is a conclusive finding that has not been changed.
No, that is the disputed question I have.
No, but that is a fine, that is staring at your face. The appeal court did not interfere with that.
No, my lord,
paragraph 7 of the judgment. Paragraph 7 dealt with this. Contention the petition raised before it against the school authority that the charge sheet was not served upon the petition.
charge sheet was not served upon the petitioner was negated.
It was held the decision authority in
Suspended in context of the refusal of the original
the
petition.
decision remains. We cannot reopen this.
Registered post. The coordinator may have also said, I'm not on, that is the factual issue. Because he is no more in the world.
No, so
Now
today today proceeding started and culminated in the order of dismissal.
No, my lord, the dismissal, this is the very vital point. Para 20 of the judgment, if your lordship kindly takes up. Para 20. Mr. Bari submits that while conducting a disciplinary proceeding against the delinquent, it is the burden, duty, and obligation on the authority conducting such proceeding at every stage. Whenever any decision is taken against the delinquent.
Pausing here for a moment, after the inquiry proceeding was over, you have been served with an inquiry report by the disciplinary authority. Inquiry officer is not, he said, proved or not proved.
I'm not on that.
Inquiry officer, he say either you are guilty or not guilty.
Yes.
Then it's for the disciplinary authority to decide whether disciplinary proceeding.
This is for the disciplinary authority.
So when this disciplinary sent it to you, which is in the nature of a second show cause, you have a right to say.
What the rule says, each and every stage board's approval is necessary. First stage, second stage, even before the dismissal, board's approval is necessary. While approving the decision of the disciplinary authority, or the inquiry authority, or the school authority, my lord, each and every reason is to be recorded in terms of the judgment. If your lordships kindly have a look, there is no discussion. I relied this judgment. There is no discussion.
Forget about it. Question is this: today, it can be safely presumed that the disciplinary proceeding they have initiated on the basis of the order of the inquiry officer. Board, I think, is there. Board is appearing. Must be appearing. Who is for the board?
For the secondary board, your lordship.
So after the inquiry office report, was it sent to you for approval?
Lordship, kindly come to my affidavit.
No, just tell us. It was sent to approve.
Lordship.
You approved it.
Without any
Respond and
That's
page,
different issue. You approved it.
Lordship, page 20.
Ask the disciplinary procedure authority to continue.
Lordship, page 21.
At that stage, you did
page
not
23, your
question it. At that stage, you did not question it. Try to understand this. You did not question the wisdom of the board to proceed with the disciplinary proceeding. Disciplinary proceeding comments, you also did not participate.
Lordship.
You also did not participate. At the appellate stage, also you did not participate. Everything went next party. Now, for the first time, you are coming up in your affidavit disclosing few documents, saying that if these documents were considered.
Okay, first time, the problem is this Malad is no more in the world.
In about 2021, he was very much alive. So these documents are relevant. Please show us from your writ petition. You made a representation to the disciplinary authority disclosing these documents are relevant. And these documents were not dealt with by the disciplinary authority.
No, I tell you, lordships, because the affidavit.
Please, Mr. Bhatt.
No, I follow you. I'm not. I follow your lordships. Now my whole content. Madam, my whole contention before your lordships, whenever these reports and everything was forwarded to the board is duty bound to examine.
Challenge this.
Yes, I have challenged that. That
in this
decision. And
in this writ petition.
The writ petition, the challenge was the decision of the board.
That is when the final order of the appellate authority has been affirmed by the board.
Yes.
So you have not challenged the initiation of the disciplinary proceeding saying that is bad in law. Or you have not, first of all, you have not participated in the inquiry.
No, that is there.
The disciplinary authority would have appreciated if you have made a representation with the documents alleging that look here these documents on the basis of
reconsider. My point is this: everything was there in the affidavit. when it was pending, everything was disclosed regarding my innocency. So it was not taken into consideration.
It should be part of the disciplinary proceeding. Show us that whether during the proceeding you have disclosed these documents.
No, it was expertise. Always
Yeah,
expert.
no, you have not even submitted your answer to the charge sheet.
No, well, that is only that document is also not legible. Well, if
Sorry,
your
Mr. Bari, take it.
if your lordships kindly have a look
Take
to
it
this.
off, take it off.
Page 61 of the 61. It is.
The appeal is arising out of an order. I consider the parties the appeal and the applications are taken up.
May I place that judgment to your lordships before? No, well, that is very much required. If your lordships kindly deal with that judgment.
আজকে কত তারিখ ছিল?
নাই, আর দুটো কপি নাই? হ্যাঁ? এদের কাছে নেই স্যার? নাই। একটা করে কি করে কপি? Well, we have given earlier. Well, three judgment is in the file we have handed up earlier. One, Sri Maya Shankar Cha, second, Mamata Banerjee, third, Arun Kumar Haish.
Yes.
Well, first your lordships, Maya Shankar Cha, your lordships kindly. Suspension. Special approval of the suspension. Special order. Suspension, page 44. On 55. This makes no reason by this.
You have not answered to the charge sheet. You have not answered to the show cause notice.
Yes.
By the
Charge sheet, wallet, it appears, but I am also, your lordships kindly have a look to this.
Even you have not made a representation with the disciplinary authority.
My lord, my prayer before your lordships, whether the disciplinary authority, the board, while first stage and second stage, when they are not required to give reason, they said, your lordship, kindly see the order of the dismissal. Page 154. Your lordship, kindly see. Proposal for approval of the dismissal second stage. I am directed to inform that the committee under section 24 of the West Bengal Board of Secretary dealing with the cases of the disciplinary proceedings and non-teaching staff, the committee, after careful consideration facts and circumstances of the case, on perusal of the document, resolved that the proposal for approval dismissal be approved. What is the reason? Why it is approved? What is the findings? What is the disciplinary authority findings? Well, the categorical judgment it says, but you cannot do that. Unless you give support the reason in favor of the dismissal order when it is passed by the board. As Shankar Jha and also the Mamata Banerjee, your lordships can leave. Exactly in same nature of the case. And judgment of the three judges bench also considered the same. Orun High, if your lordships kindly have a look to this.
What do you mean by section 24 committee? Your affidavit? Section 24 committee.
Settlement judgment, your lordships kindly have a look to this Orun High. Page 41 and 42, paragraph 41, 42. Page, please.
Dismissal to approve second.
Yes. And my lord, Maya Shankar Jha and Mamata Banerjee, these are the two judgments supports my contention that and in a Orun Height case, three judges bench the considered initially and paragraph 40 and 41, 41 and 42, 41. The managing committee must then take a decision by recording a reason which should indicate how it came to the conclusion for taking a disciplinary action against the delinquent. Such reason must be supplied by the managing committee to the delinquent. Similarly, in the second stage, after delinquent is given the opportunity, the proceeding, the proposed punishment, the managing committee must give its reason in support of the proposed punishment and supply the same to the. Finally, WPSC would be granted to refuse the approval of the decision of the managing committee at both stages on the basis of the materials on record without considering any document not supplied to the not served. By the order of the reference, the merit of the appeal are placed before the court for disposal.
The appearance at the instance of the widow of the deceased. This was at the relevant time. RTN institution. You have to refer to as a state school. On 6th January 2006. The letter he was the headmaster, was it correct? State headmaster. Alex. Potential lapses. And asked for clarifications. Nature of charges are as follows. However, said this after the Mr. Malik Rahman. Mr. Malik Rahman. Mr. Rahman both Managing Committee's meeting of the first 2026 resolved to suspend Malik Rahman from service. Forward the proposal to the board for necessary approval. Suspension order was unsuccessfully challenged with a single judge. Was of the opinion that in spite of repeated opportunities, Malik did not respond, but in spite of various opportunities. Now, was of the opinion was kept under suspension. He was kept under suspension. He was kept under suspension. Alleging that was kept under suspension of the management of recognized non-government institutions, aided and unaided closed roots, 1969, bracketed for fraud, 19 filed it. পাবে না যেটা পঁচিশ মনে লেখার চেষ্টা করো ফাইল দ্য রিট পিটিশন kept under suspension and the committee that decided the disciplinary proceeding violation of section resolution. Finally, WP 4844/W of 2006. For short, first repetition values. This was dispersed by Honorable Janet 2007 by one single judge. Of the school authority to initiate disciplinary proceeding against the original petitioner. Dated 2nd 2006 was not interfered with by the single judge. And as the single order being BAT number 808 of 2007, the FMA number 2757 of 2007, that is for short, the appeal was also discussed. Division date was interpreted the finding on the factual aspect of the matter dealt with by the one single judge, disposing of it However, however, the Honorable Division, however, the coordinators gave an opportunity to the original petitioner to participate in the disciplinary proceeding by filing his reply to the show cause notice upon him. Actually, it is not in dispute that the petitioner did not respond to any of the show cause notices at any stages of the proceeding and had challenged the decision of the Managing Committee dismissing the writ petitioner from service the approval of the board. The approval of the board. So, senior counsel appearing on behalf of the it's that the board at every stages had mechanically affirmed the arbitrary action of the managing committee without adhering to the law laid down by the special bench in Arun Kumar High versus State of West Bengal others, Mamadi 1999 bracket 1 CHN 521. Our attention is drawn to paragraph 41, 42, and 43 of the decision of the special bench, which is as follows. At this stage, it is order to find the Mr. The party has also referred to the decision in March of Kocha and planning versus so that if to argue that if the initial order of suspension is bad, the entire proceeding is required to be declared as vitiated. Moreover, at every stages of the proceeding, the board did not had failed to discharge its ability not for continuation of the disciplinary proceeding against the petition. It's the original petition. They are unable to accept the said submission. The admitted position that every opportunity was given to the original petitioner to make representation all stages of the proceeding. It is no more open for the petitioner allege at this stage, to raise an allege at this stage that there has been no proper service of the charge sheet. The earlier proceedings by the division bench had arrived at a finding that the writ petitioner was that the writ petition, the original petition was service of the notice, and thereafter had allowed the writ petitioner to make a presentation since the show cause notice and participate in disciplinary proceedings. In spite of giving such opportunity, the petitioner did not participate in the said proceeding. It is now being alleged that the writ petitioner was prevented from participating in the discipline. However, such allegations not substantiated. Could not be substantiated. Board had filed a detailed application wherefrom it would appear that the charge sheet that the unanimous decision of the management committee in its meeting dated 16 January 2026 to issue a charge sheet against the original writ petitioner for financial for defalcation of fund was duly approved. On 20th of Swati 2007, resolved to appoint an inquiry officer, bracket called secretary of the school, bracket close, and a presenting officer. As per the direction of the management committee, the inquiry officer commenced inquiry procedure following charges. Page 6, 1 to 6, page 6, 1, 2, 3, 4. Now start in a positive. Sorry, it's chota. এটা Roman 1, Roman 2 করে ছিল chota. The school authority also had lodged a FIR the petitioner in spite of all opportunities. The inquiry officer proceeded with the inquiry and submitted a report. Now, first rather than inquiry, but failed to even reply to the charge sheet. Reply to the charge sheet. So, considering the matter, considering the aforesaid, the 19th committee of the school in its meeting dated 16th March 2007 resolved to initiate the first stage of the civil proceedings against the writ petition. Proposal was sent to the court. The matter was placed. The committee considered under section 24 of the of the West Bengal Board of Education Act 1963. The board in its 171st meeting held on 10 June 2008 approved the proposal and hence the proceeding continued. While the matter was pending, the Honorable Division Bench on 15 December 2008, on 15 December 2008, permitted the original petitioner to participate in the disciplinary proceeding by filing his reply to the proposed notice. In compliance with the said order of the Honorable Division, the school in meeting dated 23rd December 2008 to issue a charge sheet as forwarded it to petitioner on 24th December 2008. Despite the receipt of the said charge sheet, did not reply As a result whereof, on 19 January 2009, the managing committee unanimous resolve to appoint an inquiry officer and also a presenting officer to inquire to hold the also an inquiry officer to also an inquiry officer inquiry officer and also presenting officer uh, for the discipline proceeding to be initiated in terms of the charge sheet. Proceeding went on perfectly. Writ petition of the original petition did not participate in the same proceeding. The inquiry officer submitted his report for the binding committee on 24th March 2009. The inquiry officer The inquiry officer in his report has also stated that in spite of repeated opportunities, the writ petitioner did not appear and participate in the same proceeding. On consideration of the same report, the managing committee in its meeting held on 25th July 2009, unanimously resolved to issue a show cause notice the petitioner asking him the petitioner seeking his response as to why his service should not be terminated. The notice was served about the on 29th August 27 July, on 29th August 2005, the managing committee of the school further sent a show cause to the original petitioner, giving him a further opportunity to submit his reply within the receipt of the notice. In spite of service of such notice, the original petitioner did not respond. In view thereof, managing committee meeting on 19 September 2009 unanimously resolved to dismiss the original petitioner of the school, the writ petitioner from the school, and send the proposal to the board for necessary approval. The board in its meeting in its 179 meeting, held on 4th December 2009, of deliberation had accepted the proposal of the managing committee. So, held on, sorry, প্রটেস্টটা পরে বলতে হট করে বললে তো বুঝতে পারবো না। No, resolve to dismiss and to dismiss the original petitioner and send the proposal to the board for necessary approval. Matter was placed in the 179th meeting of the board held on 4th December 2009, when the committee considered the proposal. The matter was fixed on 12th February 2010 for taking a decision. Thereafter, the board in its 181st meeting held on 12th February 2010 deliberated of the issue and deliberated on the issue and after careful observation of the facts and circumstances, perusal of the documents resolved by proposal for approval or dismissal, bracket is second stage of decision proceeding, bracket close. Against the headmaster, school be approved, provided there is no contrary order of the Honorable High Court. As on the date of the said decision, there was no contrary order existing in favor of you. The affidavit filed by the board disclose the documents to show that at every stage the approval was obtained from the court. The absence of any representation being made by the writ petitioner at any stage of the disciplinary proceeding, always sufficient opportunity was given to the original writ petitioner to present his case with sufficient documents. Here of the view that the ratio-less decision of the three decisions relied upon by the petitioner inapplicable. Only inapplicable. It's not possible. It is not possible. So we are unable to accept that there has been mechanical affirmation of decisions of management committee. Whatever documents the management committee had, along with the report of the inquiry officer, were forwarded to the board for consideration. The petitioner had the opportunity to demonstrate that the petitioner is the most competent. That the original petitioner is first. By the addition of his inexplicable conduct and a stoic silence maintained at every stage of the proceeding. The petitioner cannot run around and turn around and rely upon the decisions which are apart from the fact actual distribution cannot have any manner of application. Consideration the applicant applications failed, however, there should be orders to post. Does not appear from record that the board has mechanically affirmed that a political mechanically affirmed the decision. Nothing. But it does not appear that the board has mechanically affirmed at any stage of it.
Sorry, petition. Malad, before rising, Malad, item number 50, Malad, kindly keep it on 9th. Item number 50, Malad, kindly keep it on 9th, Malad.
Which the other side?
For the state.
What?
But I have some difficulty tomorrow because today, original side next.
No. You want to when?
Well, 9th of.
9th. Yes. On the prayer of the land council for the appellant, let this matter be listed online. On the prayer of the land council for the appellant, let this matter be listed online.
Yes,
আমরা আড়াইটে বসবো, ঠিক আছে? আড়াইটে।
Original side, na?
Original side. আটটা আছে হিয়ারিং হিয়ারিং
After two original side will continue.
Yes, original.
All right.
My lord, in item number 1, my lord, upon instruction I am submitting, my lord, in this matter, my lord, Honorable Justice Spitara has appeared as an official liquidator. Upon instruction I am submitting. My lord has appeared as an official.
Apart from this, my lord, this review application is arising out of the order passed by your lordship sitting with Justice Uday Kumar.
What is this, a review application?
Review
Yes,
application.
An order passed by your lordship along with the Honorable Justice Uday Kumar. That order has been preferred for review, lordship. So on the last occasion there.
No, myself sitting with Justice Sridhar Rai Chaudhary.
Yeah. Right, Justice Aishwar.
And then, is it a review application?
Yes.
An application for review.
Application is for the lordship condonation of delay. There is an
delay
of lordship preferring the review.
The review application.
Yes, lordship.
So review, order of the review.
Yes, you are correct. So direction was given to State Bank of, I am representing the State Bank of India, lordship.
So the fact that one of us.
Five stakeholders.
The application. The matters are released from our list. The matter is placed with the Honorable Chief Justice for action.
Yes, lordship.
All the list.
I am proceeding for the respondent.
এটা দাও আমাকে এটা দাও
এটা দিন না ওটা নয় ওটা Lord, a short question, my lord, has been involved in this case. My tender.
Yes.
Lord, tender was accepted and I was found to be a lowest bidder. And Lord, grant was also made. Bank guarantee was also submitted before the authority. Now, Lord, the proposal for submission of the bank guarantee form, Lord, according to the tender condition, it has to be deposited within 60 days. But, my Lord, it was sent, form was sent on us after, Lord, 60 days. Immediately thereafter, my Lord, we submitted the bank guarantee, we allowed to do the work. Now, my Lord, we allowed to do the work according to us, my Lord, 9 lakhs and odd, and according to them, my Lord, 8 lakhs, 7 lakhs and odd, according to them. Now, Lord, in the meantime, what happened, if your lordship kindly look to the order dated 4th of November 2024, your lordship's order. Mr. Sakoshen, learned advocate appearing on behalf of the earth, submitted that the work forming the subject matter of writ petition has been duly executed by another contractor. And practically the appeal has now become infructuous. Lord, to this my only submission before your lordship is this, there is a arbitration clause. Now, Lord, whether the cancellation of my tender, Lord, after the work has been permitted, is illegal or not, for which my remedy lies blood for the purpose of damages, breach of damages, by contending that the order is illegal, arbitrary in nature. But the read court blood contractor was appointed and work was completed according to the respondent, my lord. That was not stated to the read court.
Yes, it was.
That is why the read court decided on merits.
No,
Read court
there is
decided on merits.
There is a letter to give further effect to the termination letter. That was your prayer. Your prayer was that the termination letter is bad.
Yes.
In the read.
In the read.
Correct.
In the read, my lord, my prayer was termination is bad.
Yes.
And before
But,
the
my lord,
report
according to
itself, we
them,
had indicated
no, according to them,
our opposition.
no, question is, my lord, after the termination, that work be allowed to be permitted by us. Lord, that is our contention. Now, my lord, according to the changed circumstances, Lord, my remedy is to either for suit for damages. Here, arbitration clause is there. Therefore, I shall have to pursue for the arbitration clause. Lord, that fact was not stated before the read court.
It was in my affidavit in opposition.
This contract contains an arbitration clause.
Contract contain the arbitration clause.
You filed the read, challenge the thing.
Termination was challenged in the writ petition.
No, but my lord, then in that case, I shall have to satisfy your lordship on that, on merits. I shall go on merits then. I elect, my lord, two. If they pose on that question, then, my lord, I shall have to elect, my lord, for the purpose of deciding the petition on merits. Whether the read court, my lord, proceeded on the basis of my contentions, and my contentions have been accepted or not. Lord, a very short question. Lord, may I invite your lordship's kind attention. First of all, my lord, letter of acceptance at page 39. Lord, short list of dates, my lord, I have prepared for your lordships, which is very material in my case.
No, the read petition was decided on a limited issue. That is at page 157. It was on a very limited issue. The petitioner also, the terms of conditions of the contract.
Page 157, my lord, I am coming, yes. Page 157.
Read that paragraph.
The petitioner also debarred from participating in tender for the same work. The term of the conditions of the contract require the petitioner to submit performance bank guarantee for period valid up to August 6, 2019. But, my lord, according to the tender condition,
the petitioner had submitted bank
the
guarantee.
petitioner had submitted bank guarantee valid up to 7th of September 2000 as per tender condition. And, my lord, 6 months before the work is completed, then, my lord, I can extend the bank guarantee. If I complete the work, then question of extension of bank guarantee doesn't arise.
So, construction of the performance.
The bank guarantee is so submitted, but therefore cannot be considered to be within the terms and conditions of the tender. No, my lord. In the tender condition, 2 years. As per tender conditions, my lord, bank guarantee is to be submitted 2 years. If within 2 years, my lord, order is not
performance guarantee.
That's the performance guarantee that was not submitted in terms of the clauses of the tender.
Where is the performance guarantee?
Yes, my lord, performance bank guarantee, your lordship kindly come to that. That tender conditions, lordship kindly come to the tender conditions first.
Now, my lord,
Lord, page 69. Page
nothing has
69 of
remained
the
in the
paper
contract.
book.
The contract.
But if it is wrongfully terminated, then
No, then my lord, the writ court in any way cannot go into it.
No, that is what he's saying, that my
Yes,
contract is.
if they have the right, they will go to arbitration in terms of the arbitration clause.
Lord,
But that is not their prayer.
But this finding will stare at their face. This finding will stare at their face.
Lordship can leave the finding open for them to decide, for the arbitration to decide, subject to arbitration being maintainable now. Because, my lord,
Question would be, my lord, page
I
69.
have said that the contract has already been awarded to somebody else. It is not that in the appeal I am saying it for the first time. In my affidavit in opposition before the trial court, this was my case. So, my lord, they cannot get benefit of section 14 also. It was in their knowledge at that point of time.
Lord, law is
I
no
can
longer
show
res
from
ipsa,
paragraph of the opposition.
notwithstanding the arbitration clause, it is maintainable.
If at all,
They did not take up any point that because of the arbitration clause, it has been presented, therefore it is not maintainable. Therefore, it was decided on merit, on a limited ground.
Well, only kindly take my.
No, but date of expiry is according to the performance grant, date of expiry is 2018. See page 125. Date of validity, date of expiry. This is not in terms of the contract.
125, yes, as per tender condition, 2 years.
No, he
Lord,
says.
pro forma 2 years, tender condition 2 years.
No, where from we get this date of 6th August 2019? Where from we get this date of 6th August 2019? Which part of the contract shows?
Lord, your lordship kindly come to the tender conditions, my lord. Tender condition page 69 of the paper book 1 to 24 months. Lord, according to the pro forma, my lord, 24 months. Accordingly, my lord, we have submitted.
But kindly have a look at the clause of 6.13.3.
Mr. Sen, let me conclude my submission first.
Yes.
Page 69, lordship. Tender condition 24 months. And well, according to the tender condition, before 6 months, if the work is not completed, then it will be extended. Then extension will be requested, then extension bank guarantee is to be given. Plot page 69. ব্যাংক গ্যারেন্টিটা কোথায় আছে বলুন তো? ব্যাংক গ্যারেন্টি Lord, page 124, my lord, we have now condition, my lord. Tender
What is the
condition.
bank guarantee?
124, my lord, performance bank guarantee was given at page 124, my lord, of the paper book. 9/9/2018. 3/3/2015, my lord, performance bank guarantee was given. Completion of work within a period of 2 years. According to the tender condition, 2 years, not 3 years. Conditions আছে না shall be submitted within it are submitted submission.
Yes, 123. So as per clause 6.1.13.1, you are required to submit requisite performance
2
guarantee
years, my lord.
within 60 days
2 years.
from the date of issuance of LOA.
Lord, page, my lord.
123.
120.
3.
123, lordship. Lord, this is total wrong, my lord. That if your lordship kindly come to at page 121.
Now, where is 6.13.1?
Lord, the letter dated 6/8,
6.13.
2019.
That is at page 56, volume 1. That is 6.13.
That is time for submission
Yes.
of the bank guarantee.
Yes.
But they supplied the form of the bank guarantee after 60 days. They accepted it. Then they wrote a letter to submit a bank guarantee. We submitted a bank
What is
guarantee.
the date of letter of acceptance?
60 days.
Yes, my lord. Date of letter of acceptance is 6th of June 2016.
2016.
Yes. Take it. সেটা কোথায় আছে?
Page 121, C form করেছে।
So, you have given the bank guarantee beyond 60 days.
Lord,
Beyond 60 days.
because, my lord, that was submitted page 121. Because form of submission of bank guarantee was supplied. Lord, form of bank guarantee was supplied after 60 days by the agent of the respondent. Lord, it is a reciprocal obligation on their part. Otherwise, I cannot. Lord, 15 September 2016, myself gave us.
This appeal is arising out of an order passed by the Honorable Single Judge on 6th August 2017, in which the letter of termination dated 26 November 2016 was of the challenge. At the earlier occasion, we attend this matter in order to ascertain whether the appeal has now become infructuous. Your awarding of the contract in favor of third party. The Honorable Bengal Senior Counsel appears on behalf of the petition. The appellant submits that in the event the termination is said to be provision or wrongful, the appellant is entitled to claim damages before the appropriate forum, as the court may not be the appropriate forum to decide the quantum of damages. Reference is made to the arbitration clause in the contract. Published in the Senior Counsel appearing on behalf of the respondent is submitted that the dispute arose. The dispute arose on 26 November 2016 when the contract was terminated. The appellant going to present that the appellant knowing fully well that the appellant had to remedy under the article as seek remedy in arbitration, has filed the writ application, and the time spent in this proceeding cannot now be interpreted in favor of the appellant. So that is good evidence. Next part. Contract contains an arbitration clause. In exceptional circumstances, the distribution is maintained. The learned single judge has at the threshold found that that the performance guarantee is not in accordance with clause 6.13.1 of the contract. Admittedly, it is not in dispute that performance guarantee was furnished. Performance guarantee was sought to be furnished beyond the period stipulated under the said clause. This aspect was considered by the learned single judge. This aspect was considered by the learned single judge. In view thereof, with not finding decision to interfere with the order passed by the legislature, the appeal stands dismissed. However, there should not be process.
Lord, if your lordship kindly look to page 42. Lordship kindly look to page 42.
Nothing.
Lord, pro forma that was supplied to us, my lord.
Not even raise the issue.
Pro forma supplied to us, my lord, after 60 days. And they accepted the bank guarantee.
This is not a question of accepting. Termination was valid on.
They only prayed for, my lord, extension. Allowed us to work. My lord, this argument was not answered.
The work was never awarded to you.
No, work order was awarded. Work order was awarded. You are allowed to perform work up to 9 lakhs. According to them, 8 lakhs, 7 lakh and what? Lord, this is the scenario. Lordship is required to hear it, my lord.
Work was terminated, retendered, and awarded to.
No, that is not the question. They accepted it.
They have done the work. If you have allowed them to do the work.
Yes.
If they have allowed them to do the work, then notwithstanding this.
No, I don't, my lord.
No,
Not my case, my lord. Your lordship will see my affidavit in opposition.
Look to affidavit.
Kindly see my affidavit in opposition.
Opposition. Lord, affidavit in opposition at page. Lord, volume 2, my lord.
Page.
Kindly see paragraph. There was no agreement which was approved.
No agreement. Lord, kindly page 135. According to them, that Pondeep was instructed to carry some minor work till submission of the performance bank guarantee and signing of the contract.
That was not in terms of
Page
the contract.
135. No. Total approximate value of work carried out.
The Banerjee, that is different issue. If the formal contract was not, you are allowed to do some work.
The contract was submitted for signature. We have submitted.
Kindly
They
come to
did
paragraph
not.
6 of my affidavit on opposition.
Lord, your lordship, kindly look to page 42. Kindly look to page
Paragraph
42.
6, your lordship.
No. First of all, my lord, whether we are allowed to do the work.
There was
2% of the contract value.
There is no question of the writ petitioner starting the
Lord,
work.
we are allowed to work. Lord, page 135, 2% of the contract value. They admitted. And page, my lord, first of all, page 42, when they supplied it, Lord, it is unfairness in action. Page 42, my lord, myself supplied the bank guarantee form, my lord, on 16th of August 2016. After 60 days.
Paragraph 6 of my affidavit, my lord, clearly spells out.
Page 42, my lord.
Dealing with paragraph 7 and 8 of the application.
Page 42, my lord, says 16th of August 2016. And my lord, date of acceptance of the tender.
My case is work has started much after termination of the contract upon awarding of the work to the new contractor by fresh tender process.
Lord, page 39. Page 39, my lord, letter of acceptance 6 June 2016. Therefore, it would be, my lord, 6/7, 6/8. Lord, they supplied, my lord, 16/8 in a state of 6/8. Is it my fault?
They have accepted it.
Then, my lord, I followed the tender condition 2 years. And 6 June 16 within 2 years. We submitted 2018. Lord, out of which, according to them, 2%, according to us, no. More than that. But we are allowed to work. They admitted it. And Lord, look to their letter. Their letter, my lord, shows that.
In opposition to the writ petition.
Volume 2. যেটা লেটার এতে হ্যাঁ পেজ 42 এর পর পেজ হচ্ছে 40
Page 121, 15 September.
Lord, then 121 my lord page. Lord, page 42 my lord. It was supplied my lord after 60 days. Form of the bank guarantee was supplied to us after 60 days.
Kindly take.
They could have terminated before that, my lord, instead of supplying the forms. Page got to page 121. If your lordship looks to page 121, then my lord, I shall draw your lordship because 6/8/2019 letter I have annexed. I have also annexed 16/8/2016 letter. Nowhere, my lord, it has been mentioned. 6/8 lordship, kindly page 32. Page 121, page P9, my lord. First of all, bank guarantee was supplied after 60 days, as per page 42.
No, why do you say so apart from affidavit? Any letter? Any letter have you said that you have given this? Have you said so in your letter?
Yes. My lord,
letter?
we have said so in my letter.
Did it?
In our letter.
They have given performance bank guarantee. We have.
Lord, page 42, lordship kindly come to with reference to the above mentioned work. Page 42. You are requested to submit the performance bank guarantee so and so in terms of 613 of the instruction of tenderers as per format of the bank guarantee enclosed herewith at the earliest. Lord, page 42, my lord, 16th of August 2016. Lord, now our letter is page 46. We have given bank guarantee immediately after receipt of that page 46, my lord. Performance bank guarantee also submitted
Will be submitted within a few days.
and will be submitted within few days. Then, my lord, we have submitted page 47. Performance bank guarantee was submitted page 47. At the earliest, they say within 1 month we have submitted the performance bank guarantee. Page 47. Then, my lord, page 121. Lord, page 47, we have submitted. Page 42, my lord, their agent, my lord, supplied the bank guarantee format. Lord, on 16th of August 2016, with effect from the work order, my lord, 6/6/2016, that is more than 60 days.
Where is that clause you just read out 6 point?
Lordship,
That is at page 56.
Before that, Lord, before that, one thing, may I draw your lordship kind attention? Lordship, kindly come to page 121. This has reference to a letter dated 6/9/2016, wherein you have submitted performance bank guarantee valid up to 7/9/2000, although you are advised to submit performance bank guarantee valid up to 6/8/2019. Now, my lord, your lordship kindly come to the letter dated 6/8/2019, page 32, my lord. Page 32.
Page 32 is not telling.
Lord, 6/8/2019. Page, my lord, I am giving that page. 30, page 39, my lord.
No, on 16th August, they have forwarded you the bank guarantee. That is a letter of page 42.
Yes.
So you are supposed to give.
Then, my lord, we have submitted the
so
bank guarantee.
Letter of acceptance is 6th of
June.
2014.
16.
And
16/6, my lord.
within 60 days, you have to give the.
Yes.
Beyond 60 days.
23rd August is the time limit.
16/9.
You are supposed to give the performance bank guarantee by
23rd August.
by 6th
No,
August.
no.
6th.
No, with effect from the
6th
date
August.
of, my lord, the work, with effect from the date of the
Letter of acceptance.
date of acceptance.
That is your
Acceptance
contract.
dates, lordship kindly come to the acceptance date. Page 39.
Page 39.
Page 39.
6 June.
6 June.
So letter of acceptance is 6.
Therefore, my lord,
6 June.
date is to be reckoned with effect from the date of acceptance.
So 6 June.
Yes.
So 2 months will be July, August.
So 6
So 6th
August.
August. You have given this much beyond that.
No, 6 August. Lord, they applied, my lord, 16th of September.
No, that is not the.
The 16th of August.
If they are supplied on 16th of August, then on the 16th of.
Lord, 6 of August, my lord, is the last date. 60 days.
But you have sent it on 16th of August.
Yes.
But no, my lord, here kindly see, this letter of acceptance was accepted on 22nd of June.
No.
So, my lord, 22nd of June, we will have 2 months.
You are sending this myself. Is sending the bank guarantee only on 16th of August.
But if your lordship sees the clause 6.13. Yes, I've seen that. But
No,
that
if
we have,
you require.
there is no format which is required.
No, if you are, then why you forward this? You could have not said it's not required.
That is a format has been given because, but
Why you have said enclosed here? That means that is approved form.
But if your lordship kindly comes to the clause once, 6.1.
No, that's true. But this is again, when you send, you see 2 things are there.
Yes.
You have sent the bank guarantee on 16th of format on 16th of August.
Yes.
So your contract shows within 60 days from the date of letter of acceptance.
From the letter of acceptance. Acceptance of
No,
the letter of acceptance.
No, not from letter of acceptance, from the date of that order.
No, it is up to, it is from the performance guarantee within 30 days from the date of issuance of the letter. So you are supposed to give the performance guarantee within, that means 6th of July. 6th of July. You have not given within 6th of July. Extension of time for submission of is 30 days and up to 60 days from the date may be given by the authority who is competent to sign the contract. However, a period of interest and such. In case the contract fails to submit the requisite PG even after 60 days from the date of issue of the LOA, the contract shall be terminated.
Yes.
So it's not dependent upon any format being given by them to you or.
As per this performance bank guarantee, আমার থেকে 17 লাখ টাকা নিবে।
Lord, as per tender condition on the date of the page 39.
After the expiry of 60 working days, that is coming to 23rd of August 2016.
Lord, according to the tender condition, it is 6 August 2016. Lordship, kindly come to.
Of the LOA,
Lord, LOA, Lord, as per tender condition, it will count. It will be counted with respect to the date of LOA.
At a line at Kudo.
With respect to the date of LOA, Lordship, kindly come to the tender conditions.
Mr. Haradhan Dhanuch, Mr. Haradhan Dhanuch.
They accepted the amount thereafter, my lord. Then why they have accepted my bank guarantee? They ought to have stated that you have submitted beyond that period, therefore I am not accepting the bank guarantee. They have accepted the bank guarantee. Then only ground is no extension can be given. 18 as it was given.
Works, they have executed works for which they have received some payment. Point paragraph further. In the academic filed on your secretarial authority and have not housed secretarial authorities and as
6/6/2016.
16th August 2019.
that performance guarantee was not submitted even after the expiry of 60 days, 60 working days, that is 23rd August. It is not in dispute that the letter of acceptance was issued on 6 June 2016 and on or before 6 July 2016, the performance guarantee of the appeal court. However, the contract permits a further period of 60 days, which means 6th of August 2016. It appears that even on 23rd August 2016, performance reliance on the
Your Lordship, kindly look to page 40. What date is to be reckoned? Date to be reckoned is, my Lord, 6/6/2016.
Reliance on the letter dated 16th August 2016.
The completion time for the work shall be 24 months from the date of commencement. The letter of acceptance shall also be treated as work order, and the date of commencement shall be reckoned with effect from 6/6/2016.
Very well considered. Next matter, please.
Lord, this is the interpretation, my Lord. We have argued, my Lord, before the Reed Court. Reed Court did not answer to that.
Next matter. Yes, next matter. Yes, give the papers.
Item number 3, Your Lordship. Item number 3, I am praying for, it's an old matter, I am praying for 2 weeks time, Your Lordship. I am for the petitioner, ICAI.
How should we হবে কিছু কেন হাতে নিয়ে নিও না দু লাইন লিখেন পেপারটা একদম ধরো না Attendance is made on behalf of the. We are giving you 2 weeks time. We are giving you 2 weeks time. That's all.
Yes, sir.
Item number 3 The matter stands adjourned for 2 weeks. If the respondent is not represented, let an appropriate notice be served upon the respondent by the learned advocate on record for the appellant even. Next.
Amit Ghosh.
Yes, item number 4.
Malad, item number 4 to 7, Mr. S.K. Singhi is appearing. Malad, this is old matters coming, suddenly has come up in the list. I'm
5 and 6.
weeks time.
Let's 5 and 6, perhaps she can't say anything. 5 and 6, your Lordship will have to release, my Lord.
5 and 6 should release. 5 and 6 release on personal. 5 and 6 release on the 5 and 6 release. 5 and 6 release the personal ground of Amar as Lodha was as
he is one of the appellants in one of them.
As separate for there's the petition as is one, no, in view of the fact that one of us, Aman Nandu, had represented the petitioner in similar proceedings, in connected proceedings. That was released from our list. By the sixth, it's the same thing.
Grateful to your questions.
Silent sixth বুঝলে?
My lord, in item number 4 and 7, I am for the petitioner. I am led by Mr. S.K. Singhi. These matters are very old matters, my lord. I am praying for 3 weeks time.
2 weeks.
Yeah, grateful, your lordship.
Same order. Give notice to the other side.
Grateful, your lordship.
4 আর 7 টা same হবে as 3. Yes, 8.
8 as a mistake for the Union of India.
Union of India. Union of India is not a party.
Yeah.
मेरे जो ना ग्यारह दिन होगा
द्वारका प्रसाद भैया तो 8. No, my lord, in this matter, there was perhaps an order by this honorable court directing the Union of India to appear. Item number 8, man.
8.
Well, appearing, item number 8, Mr. Rajiv Rai appearing for the ICI, your lordship. And I am praying for an accommodation, your lordship.
No, but who is
As he
appearing
is
for the
on his leg before the court number 39, your lordship.
last order? Last order. Reference, please. The reference which is for the so Chartered Accountant Act আছে দেখি Chartered Accountant Act.
Has not been affected.
Your lordship.
Service has not been affected.
আরো আগে কোথাও আগে আমার নাম
It was mentioned by you.
Yes, your lordship.
Then you are not ready.
Your lordship, he is present at the court, your lordship, but at present, your lordship, he is appearing before the court number 39, your lordship. And it will take some time, your lordship. Your lordship, I am praying for an accommodation, your lordship, and fix and date, your lordship.
order number 17. My lord, by the order dated 7th February
Yes, yes, you are
2020.
good. Yes, of course.
So, physical charge. Right. Proceed करते गए और settle on like my lord here.
You are appearing.
For the applicant, my lord.
What is, please tell us how this reference is under what provision?
My lord, under section 21, subsection 5.
But it doesn't talk about any reference.
My lord, may I?
Yes, we have the book.
My lord,
Sir,
sir,
give us the problem.
it will be under old act, my lord. Sir. Follow it up. এই ওটার ইয়ারটা বলো না একটু চার্টার্ড অ্যাকাউন্টেন্ট অ্যাক্টের ইয়ারটা বলো ইয়ার 1949. So under subsection 5, the reference has to be
Yes, yes.
under subsection
You
5.
may keep this book, so you may require this.
My lord, my lord. Actually, these books are not readily available, my lord.
So you found a misconduct.
My lord.
So under 21(5), you have referred the matter to the High Court
My lord.
for approval.
For reprimand and removal, lordship, kindly come to subsection 6.
So what is your response? Union of India has to give a response.
My lord, I have, as per the direction of your lordship, I have served. Earlier, I have also served, and as per the direction of the last order, lordship, I have also.
They have not filed any affidavit.
They have not filed any.
You have not filed any affidavit.
You also have possibly not filed any. Well, as far as I remember, because the private respondent was not appearing, respondent was not appearing. Initially, that is why time was being granted.
No, under this 21(6), your response as well as the response of the member is required. Member, council and central government. Now this is a no response from the council is there because council is the authority.
Yes, my lord.
So you are required to be heard.
Yes, my lord.
But central government and the member has to also give their views on it.
My lord.
Which of the remedies?
Yes.
So we pass a peremptory order. If he doesn't appear, then we proceed with the matter.
My lord.
Where is the affidavit service?
Last order that from
In spite of service, the respondent is not represented. The appeal of service is kept to the record. However, we should give a last opportunity to the respondent.
Response দিয়েছে লাগবে
The respondent and the Union of India shall file an affidavit disclosing their response to the recommendation of the council. Recommendation of the council with regard to misconduct within 2 weeks from the date of communication of this order, 3 weeks from the date of communication of this order, 3 weeks from the date of communication of the order to the private respondent. In respect to the Union of India, since it is the said respondent respondent is represented by Mr. Indrajit Dasgupta, no formal notice is required to be served. The matter since urgent for 4 weeks. This order shall be immediately communicated to the respondent by speed post with acknowledgement due, and an affidavit of service shall be filed on the urgent date. In the event the respondent number 1 is absent in spite of is not represented, in spite of service of the notice, we may proceed with the matter in absence of this respondent.
There was a direction on 12th of July 2022 to serve under a private respondent. That I have complied with, they have not turned up. Thereafter, my lord, there is a direction of Honorable Justice I.P. Mukherjee to serve upon the private respondent. That affidavit of service I have just now submitted, my lord. They are not responding, not appearing before your
They are
lordship.
not, will decide to give them a last opportunity also.
That's it.
This is the last opportunity.
Fine.
Take this book, you give us. বা একটা বই রেখে দাও না, কোনো একটা বই এখানে রেখে দাও, এটাকে কপি করিয়ে নাও, দাও। এটাকে বলো এটা কপি করে নিচ্ছি।
I'll make sure that one copy is filed with your lordship. And the next time I'll definitely.
আমাদের লাইব্রেরিতে দেখো ওটা কপি করিয়ে দাও। থ্যাংক ইউ।
কপি নেই যে ভাই, আমাকে একটা বই দাও। একটা কপি নতুন এক, পুরোনো এক তো সব চলে গেছে।
Online appellate side, anyone is there in the appellate side, you can take our appellate side also on the officer. Yes, provided the appellate side lawyers are here. Both sides are here, we can take our appellate side matter. Show me. Other side is here. Then this collapse, that's the problem. All hearing matters were there, appellate side, original side. এবার থেকে বলে দেবে জানো তো, original side শেষ হয়ে গেলে appellate side নিয়ে নেবে। This দিয়ে দেবে immediately after completion of original side.
But so far as below 54 is concerned, appellate side list, your lordship can take it upon Wednesday, Miller, on 9th, Miller.
No, 15.
That's not charge. It's